I did. I mean, after this amount of time, you think I'd finally realize I'm muted. Anyhow, I want to welcome everybody this afternoon. We did have quite a few emails, and I think some other people will be joining us because we only have a few people registered, but I know we had several people send in questions. So welcome, and we'll go ahead and get started. If Dee Dee, you want to advance the slide? Okay. Today's topics: pandemic issues, distance learning, and comp ed, Section 7 and LRE alignment, minutes in Section 7, transition age issues, alternate assessment signatures, guardianship, and then retention during virtual learning. Okay, I'm going to take the first question about the pandemic, and then I think Dee Dee's going to take the second one. The first question is, can you please clarify that if a student's parent elects distant learning, should a distant learning plan and a PR1 be completed still? Definitely, absolutely. Because even if the student's parent, even if you're holding face-to-face school, but the parent elects to have the student be virtual, yes, you do have to have a distance learning plan. The PR1 protects you that this is what the parent chose. And like I said, you would use a distance learning plan. Now, if it got to be to a point where there was a lot that couldn't be offered through distance learning, then you would start looking at possibly amending.
Great, thanks, Helen. And you know, it's funny that we had this question because I just read legal updates today for the month, and there were 2 court cases involving distance learning plans, and they were able to rule in favor of districts in due process because they did in fact do a PR01, and they explained in detail in the distance learning plan what was going to look different during remote instruction than it would in face-to-face. And the court ruling was that even though they didn't meet 100% of the service delivery minutes as written, they did a nice job of explaining what they were able to do and how they were, modifying what was the service delivery, what it would look like. And they did not have to provide any kind of compensatory education. So I just read that a few hours ago. So thanks, Helen. And that kind of actually leads right into question number 2, which we've gotten, numerous times. And if you've been on any kind of training with Helen and I this year, if you've been to our special ed forum, you've no doubt heard us already talk about compensatory ed recovery services. So the question was, what are other districts doing? Basically, what's the feel out there in the region about compensatory ed for virtual learning? And you all are no doubt aware that Governor DeWine has already required that every district have some type of extension plan to address the COVID slide. That is for all students, not just for students on IEPs. So obviously, when we think about addressing regression that students are experiencing because of the pandemic, that is not compensatory education. And we want to make sure, I know if you've heard it before, I apologize if it's redundant, but there still seems to be confusion out there about really what compensatory services are. And remember that when we talk about compensatory, that is a legal term coined by the court system as a result of a district's failure to provide FAPE, failure to provide what was outlined in the ETR or in the IEP. And so if a district fails to provide service delivery, then compensatory ed always means an hour for hour compensation. That is completely different than recovery services when you are doing your due diligence to support students learning because of regression due to the pandemic or due to virtual learning. So I guess the answer to this question is there is no sort of common feeling or common thought around this. Some districts have in fact had circumstances where they were not able, as Helen mentioned earlier, addressing question 1, where they were not able to provide services that the child was entitled to receive. And so then they rightly addressed it saying, yep, we know that we couldn't deliver this. We didn't. And so we're going to provide compensatory ed. Here's what it's going to look like. They agreed with the family, wrote a PRO1, and everybody moved on happily. Many other districts, fortunately, have been able to still provide FAPE, even if it looked different than what it did during face-to-face instruction, and did a good job of documenting that in a distance learning plan to make sure that families understood and agreed with this is what the provision of FAPE looks like during these, uncharted times, uncharted waters, if you will, while we're learning remotely. So again, we would only want you to be considering compensatory ed in the case where you did fail to provide adequate services as outlined by a student's IEP. Otherwise, we would want you as a district to be looking at what do we need to do to ramp up interventions for our students to mitigate the learning loss that's occurred in the past year. And again, by state decree, every district is going to be looking at that in some fashion, not just for your kiddos on IEPs. And obviously, you folks as the special education administrators are going to be looking specifically for your population of students with disabilities and how you will address and tackle that. And many of you have already been doing that. Okay, so the next question and subsequent sort of explanation are all really rolled into one. But during internal monitoring review that we did several weeks ago, we got a couple of follow-up questions, and we've had these kinds of confusion or requests for clarification. So we thought we would go ahead and address these. So we talked about accommodations that are listed in section 7, both in section 7 as everyday classroom accommodations, but also accommodations that are listed in section 12 under testing. Because as you know, there's a reason that there's separate accommodations in testing versus accommodations in section 7, because students may require certain accommodations for instruction that they don't for testing, or vice versa. Generally speaking, if a student needs some kind of accommodation for day-to-day instruction, we would also expect to see that for testing situations. But sometimes students may need an accommodation for testing that they don't necessarily require for day-to-day instruction. At any rate, we talked about that needing to be a match with the LRE section. And this question was, do all the accommodations that are listed in an ETR have to be in the IEP under section 7? And the answer is kind of a yes and no. So no, you do not have to implement every recommended accommodation that is in an ETR. However, we will say this, when we do internal monitoring training, we talk a lot about making sure that the school psych and whoever is, writing the suggested accommodations as part of the implications for instruction in the ETR is really judicious and not doing a broad scope copy and paste of here's every single possible accommodation for a student with this eligibility category. And unfortunately, we do still see that happen quite often. And the reason you want to shy away from that is really two-part. One, that's not individualized to the student. And secondly, it is the expectation that if something is addressed as a need in the ETR and is called out under the implications for instruction, it is expected that it should find its way into the IEP. Now, again, that doesn't mean that if there's 20 possible accommodations that you have to have all of them, but you would certainly have to have some of them. But again, we would get suspicious, as would OEC, if we see this broad sort of broad scope copying and pasting of laundry lists of, accommodations, because again, that's not specific to the student. So no, everything doesn't have to be in the IEP, but certainly should be reflective of what's the most practical and makes the most sense from what was addressed in the ETR. So this is where we get into the match between Section 7, Section 12, and LRE. So the question arose that if the only thing that the student is pulled out of the general education setting for is small group for testing, does that have to be listed in the LRE? And it was suggested that there may have been some previous guidance that sounded like you did not have to have it in LRE. But then we said in internal monitoring that yes, you do. And the answer is absolutely yes, you do. And I'll explain this in a little bit more detail, but here's what you have to remember. If you say in Section 7, whether it's under the regular accommodations or in Section 12, if you indicate that a student is going to leave the gen ed setting, and be separated from same age peers for testing, and then your LRE statement does not make any mention of that, then your LRE statement is incomplete. Remember, LRE is to capture where the student is, and any time that the student is removed from gen ed peers, and then give the justification for why that is happening. So if the student is only removed for testing, that's fine, but that still needs to be explained in your LRE statement. So the next question was, well, what if the student has significant behavior issues and may be in like a self-contained classroom for most of the day, but wouldn't have SDI minutes that comprise the entire day? Of course not. SDI minutes are the time that you are specifically working on the goals in the IEP. It is not reflective of the entire time that the student is receiving instruction, and you all know that. So what I want to say about this is don't confuse minutes for specially designed instruction with the alignment between accommodations that are listed and LRE. LRE is not about the minutes. It's just an accurate reflection of where the student is and the justification for why the student may be removed from gen ed peers. So if you put, like, as I said, if you put under testing accommodations that the student's going to take all tests in a small group resource setting, then you've got to say that in the LRE. Now, here's the exception. If in a general education classroom, all students are given the offer occasionally to go to the empty room next door so that they can take their test in a small group, and that happens occasionally, and again, it's a universal offer for everybody, then you wouldn't have to reflect that in LRE. But if you are saying that the student on the IEP needs that small group resource setting or needs removed from the classroom for testing, then that is a removal from gen ed peers and must be addressed in LRE so that there's alignment. And this is kind of just the same thing. It's the same, just a different scenario, but same thing. So if a student is, again, LRE is not about minutes, and we understand that the SDI minutes do not match the total time that a student is in a setting. And remember, your SDI minutes are going to be reflected in Section 7 by the intervention specialist, and any that may be happening from the gen ed teacher or related services or whatever. Here's an example of what it might look like for a student who is separated for testing. The student receives all instruction in the general education setting. So you've already said that there's no removal from instruction. Student struggles during testing, even when separated within the classroom to provide a small group setting, because the student requires a distraction-free environment, a very small group, and persistent redirection queuing for testing. He or she takes tests in a resource setting. So you've made it clear that the student is not being removed from instruction. It's simply a removal for testing. And then I wanted to show you this because this is another thing that we're often asked about how you can write that a student is on a modified curriculum, even though the student is not taking alternate assessment. The student is still working on, grade level standards, but the curriculum has to be modified due to the extent of the student's deficits. And a district and I kind of wrote this together, and I just wanted to show you an example of what they put together. And I know it's a little chunk of information, but it makes it very clear what is happening and why. So the team considered the results of the most recent evaluation, progress on previous IEP goals, and delivery of services in the gen ed classroom. The team has decided that accommodations and modifications alone are not going to be sufficient for the student to make adequate progress in a gen ed classroom. And this is specifically for math and ELA. And so because the student needs direct one-on-one or small group instruction through interventions, self-monitoring strategies, scaffolding, guided practice, corrective feedback, repeated exposure, modeling of appropriate skills, and then that multi-sensory instructional strategies, and also needs manipulatives, and tools. Therefore, SPED services are going to occur in a resource classroom as well as a co-taught classroom for math and ELA. And then obviously in section 7, they're going to spell out the location and the provider for the SDI, whether it's in the co-taught classroom or in the self-contained sort of resource setting. So they've done a nice job of giving a very thorough rationale for why supplemental aids and services are not enough to keep the student in the gen ed classroom, and why there is a warranted removal and exactly what that removal will look like. And that is one thing that we would say we see as the most common error for LRE statements. Folks do a really good job of saying when the student is removed, but often forget to explain why the student can't stay in the gen ed setting with supplemental aids and services. And they usually forget to do that part and give that, complete justification. Okay, I think Helen's going to take number 6. Helen, are you talking?
Yes, I thought this was still your slide, but okay.
Okay, I can. That's okay. I can keep rambling. So yeah, we get this question a lot too, and you have no doubt heard us say in the past several years that there was a push a few years ago, specifically for related services, that if you are listing minutes monthly, that you should break out into parentheses what that would typically look like in a weekly situation. And so the question is, well, then why would we use monthly at all? And here's the short of it. The whole reason that the state pushed for everyone to do that is because if you say that a student is, receiving 120 minutes a month, it's hard for parents to understand what that looks like. We're all accustomed to it because we're in the schools and we know what happens, but they don't. And so, we don't want a parent to think that you come and spend 2 hours at one time, with their child. So, really coming on the heels of parent confusion was the reason why the push was to break it down what it typically looks like weekly. The reason you would still do it monthly is because, again, you're breaking it down into parentheses that is usually what it looks like. But when we have things that happen where, a related service provider is absent and has to make up minutes, having those monthly minutes still provides that umbrella of flexibility so that, yes, generally it's going to look like, 25 minutes a week or whatever it is. But within that, there's still the flexibility to meet those monthly minutes. And that may be adjusted from time to time due to absences, school closures, whatever the mitigating circumstances are that maybe prevented it from looking exactly like that, broken out weekly. And so that's why you want to do both. All right, and 7 and 8 are really the same, addressing the same thing. And we are often asked this: how do you come up with the minutes for SDI? Or how do you decide how many minutes should be in class support versus co-teaching for SDI? How do you come up with those minutes? And is there a formula? Is there a tool that gives guidance? And there is not. There is not a formula. There is nothing from the state that says, here's how you calculate the minutes that a student receives. And I know that's not the answer that most folks want to hear, but honestly, it does come down to doing your best estimate. What we typically say is, think about the instruction time that you have with a student. Think about typically when you're working on a skill with a student, one-on-one or in a small group or whatever your specially designed instruction generally would look like, and think about the amount of time that you can think that it generally has taken for a student to acquire a skill. And if you don't have that background, then you're really taking your best guess as to, what would the student need based on your knowledge of the student. And, you don't want to make it too low, like we've actually seen IEPs where it was something like the student would get, 5 minutes a week or 10 minutes a week. Well, you're probably not going to accomplish a whole lot in that amount of time. But if you have a good justification for that, then so be it. But you also don't want to make it something ridiculous that really could never be implemented. Remember, SDI is just the time that you're working on that specific goal. So that specific skill deficit that you're targeting. And again, so you really want to think about what you know about the student and the student's acquisition of skills thus far and what seems to be a reasonable time. And the only other thing we would say about that is, it's fine to change the SDI minutes before the next IEP. As you are working on goals, if you see that a student doesn't need that many minutes of specially designed instruction because the student is really making progress and is moving towards a level of independence, it's okay to reduce SDI, or conversely, if it's not sufficient, it's okay to increase. And you've heard Helen and I harp on the fact that, one of the things that monitors look for is that, based on progress reports, that there's an amendment made to an IEP if a student's not making gains or they master something early. That's one of the things that can be changed. It doesn't always mean you throw out the goal and get a whole new goal. It might mean that you are taking a look at those SDI minutes and maybe you need to increase them in order to support the student's acquisition of skill that will allow the student to master the IEP goal. That could be all that you have to do. Sometimes you're tweaking the goal, but not always. So always think about those SDI minutes and whether they need adjusted when you're thinking about amendments to the IEP. All right, I've been talking for a while. So before I go to the next question, and Helen is going to tackle a few, I'm going to pause for just a second and see if there are any questions about anything that we've talked about thus far. So go ahead and type in the chat or unmute yourself if there's anything that you would like clarification around. All right, Helen, now I'm turning it over to you.
Okay, that was a lot. Okay, questions for alternate assessment and transition. These are just a couple questions. I know we've been receiving a lot of questions about alternate assessment. But anyhow, the first one really has to do with transition. What if we don't get parent permission, no response to requests, to invite a representative from an outside agency for our transition students? Can the representative attend the meeting? Unless the student has complete guardianship at the age of 18, no, you cannot. And I know this often does more harm because there are, especially at the transition age, if you need to get a student, some students at times are not even hooked up with DD services, and they get into high school and parents don't know that they qualify for this, or sometimes parents don't want them to qualify for this. Number of reasons. And OOD, opportunities for Ohioans with disabilities, are really starting too in the middle school with pre-employment skills, and they are attending meetings, and also have options for kids to have summer work situations. And I mean, it's really pretty imperative to get some of these linkages, but unless the parent agrees, you cannot invite them. What I would suggest is, and I'm sure most of you have, is, because I know sometimes getting in touch with high school parents is difficult too, would be to, at least if you are having the IEP meeting and the representative is not there because the parent hasn't given the okay, to discuss at that IEP some of the situations, some of the benefits a student could have, and doesn't mean that a agency couldn't do an intake or couldn't do a meeting with the parent and student themselves outside of the IEP meeting. I know a lot of parents do get bogged down with some of the paperwork, but like I said, it really is valuable to have these different agencies that can benefit many students. But yes, unfortunately, unless you get their permission, you cannot invite the representative. So like I said, I think I would have a discussion and just offer, hey, there's these services out here, and I think it would be beneficial for you to possibly talk with someone. Okay, the next one is, do you need to get signatures on both the AASCD participation decision-making tool, the one that was just released, and the participation criteria sheet, or just the participation criteria sheet? You need them on both for this year. I mean, we know when we start saying anything about doing any kind of adjustment to the IEP, that can, we're not saying, oh my gosh, we're going to start all over with a new IEP. I think some software has caught up with a little bit of this, but basically the decision-making tool came out before any kind of adjustments with software. So basically, you're going to have to do both the decision-making tool this year and the participation criteria sheet. I think they're going to try to combine them into one, correct, Dee Dee? Or are they just going to do the decision-making tool so it's in the IEP?
We have heard that they do plan to combine the two of them.
That's what I thought. Okay.
We don't know when that's going to happen. So for right now, like you said,
Yes.
Helen, some software has embedded both, but most of your software might still just have the participation criteria form. And so you just need to make sure that you print the decision-making tool and attach it to the IEP.
Right. Okay, any questions on that? On either one of those? Okay, and feel free to type into the chat, or unmute yourself while we're talking, because this is a small group. Okay, questions about guardianship. Okay, the transfer rights start at age 18. We know at age 17 at the IEP, we explained to the parents that, if you're going to apply for guardianship of your student, if they have some parents may have done this previously, depending upon the impact on, the disability impact on some students. So basically you say that at 17, and then, well, I actually should read the question. All of our kids have legal guardian, either court assigned or the parent is given the responsibility at the court hearing. We have not been addressing this on the IEP forms. What should we be doing? Discuss it in the meeting, put it in the PR1. Does the parent and student need to sign that section on the signature page? Okay, basically, typically for students that maybe don't have legal guardianship, you talk about it the year before so parents are ready or can get guardianship. In this case, if the students already have guardianship, or the parents already have guardianship, I would make sure, and I think I know most of the students we're talking about here, that that isn't going to change at any time, like they're not going to have to go back to court or anything like that. But I would mark it on the IEP, and I'd put it in a PRO1 just because it says that you have gone through the process of, or the parents have gone through the process of guardianship, and it's there. So if that student goes on anywhere else, that that alerts whatever district or whoever is servicing the student that they do have, parents do have complete guardianship. And like I said, I don't think it hurts to put it in the PRO1. Does the parent and student need to sign the section on the signature page? I would say yes. The parent, I mean, if the student is of transition age and you want them to sign or they can sign, that's fine too. It's not anything that's going to say that the IEP is out of compliance. It's really just making sure, because we have had situations, and I know I've had districts call, when students with really involved situations turn 18 and the parents haven't done anything about guardianship, because, and the same thing happens in hospital situations, because I've worked kind of close with Children's Hospital. Parents don't realize that sometimes they don't have say. They have to go through the process of guardianship. And quite honestly, unless a student is really significantly involved, often the courts are only giving part guardianship, like for education and maybe financial decisions. But whatever, if you have a student that is 18 and really low cognition and you don't know, I wouldn't just invite the student. We've had a couple situations like, well, the parents don't have guardianship. I would, as a courtesy, make sure those parents are involved and keep explaining that if that student goes into the hospital for anything, they are not going to have say if they don't have guardianship. I know I kind of went overboard with this, but we did a parent transition academy a couple years ago, and we had Children's Hospital involved, and it gets to be really sticky. And then there are students that are granted guardianship, and I always say, ask that student if he's 18, do you want your parents involved? And as courtesy, if the student says yes, I would invite the parents. And also as a courtesy, so if you have a parent that may be looking at due process for anything, I might still offer them the choice to attend. But truthfully, once a student is 18 and their own guardianship, that is, if they have guardianship over everything, meaning education, they're the ones that attend their IEP and sign off. Any questions there? Because I kind of went above and beyond this question. Okay. Okay, Dee Dee, do you want to go here, or do you want to both tag team on this?
Yeah, thank you so much, Helen. That was really helpful, because that does get really confusing about the guardianship and the transfer of rights. So thank you for that. This last question is about retention, and specifically more about retention as it relates to virtual learning during this past year. Again, we know that most students, many students have had some significant loss and regression. And how does that translate into retention practices during this time, and just in general for students with disabilities? And the question was asked, could we also talk about, is it an old wives' tale, or is it factual that students should not be retained more than once in elementary school? And here's a couple things we can tell you. In terms of thinking about retention due to the pandemic, we would say, we refer back to what we talked about at the beginning of the hour in terms of compensatory services, that you're thinking globally about all students in the district, students with disabilities and without, and how you can provide interventions and recovery for learning loss. You certainly, as a district, are not going to retain 50% of your student population. So districts are coming up with all kinds of creative things to do to provide intervention. One of the things that we would highly recommend you rely on is a really robust and rigorous MTSS or RTI process. Thinking about things like additional tutoring, summer programs. Obviously, Governor DeWine mentioned extending the day, extending the year, et cetera, et cetera. So, districts are coming up with their own plans. Those are local decisions. So we would not expect to see an increase in retention because of COVID learning loss, because again, as educators, we have to make sure that we're globally addressing the needs of all students in coming back from, the loss of instruction and the loss of learning related to the virtual circumstances. So then we think about just retention for students with disabilities in general as a whole. And there is no hard and fast rule. What we can tell you is this. There was a study by Harvard University some time back that did indicate that there could be gains for students who were retained in the third grade, that there might be some advantages for those students. However, there is an abundance of research that speaks to the negative impact of retention of students, and that negative impact only is exacerbated by additional retentions. So just again, these are local decisions that IEP teams, teachers and principals and parents would be making together. But here's just some food for thought as we wrap up today. Many studies, including a 14-year-long study by Texas A&M University with nearly 800 K-12 students, resulted in 53 separate scientific papers being written and additional research being done, have all supported some of the things that we know are in fact negative impacts of retention. One thing I found interesting was when students were polled, 6th grade students rated repeating a grade as the single most traumatic life event possible. And that weighed heavier and ranked higher than the death of a parent or going blind. So think about that from student perspective and the social emotional toll that repeating a grade takes on a student, where kids are ranking that in terms of a traumatic event. And if you know anything at all about trauma-informed care, that's probably something that none of us even thought about, that we wouldn't even consider that being a traumatic event or an ongoing trauma, when in fact, from the child's perspective, that is a persistent, pervasive trauma when they are retained a grade. So a couple of other things, retained students as a whole are less likely to receive a diploma by the age of 20. They are less likely to achieve competency ratings in academics, less likely to attend post-secondary educational programs or college, have a lower employment status, are paid less per hour, and specifically for students with disabilities who are retained, there is generally an increase in behavioral problems. We see reports of lower self-esteem. There is a marked decrease in attendance, and that is true for all students, not just students with disabilities. Students who are held back generally have much lower attendance than students who are promoted. And students who are retained generally have lower outcomes in reading, writing, and math. So again, we're not here to debate the merits of retention. We're simply sharing some of the research and some of the evidence that is out there. And again, you know that if you're researching anything, you can find a study to support whatever argument you're making. There certainly are those who do maintain that there is benefit for elementary students to be retained in early grades up to third grade and including third grade. And again, there may be something to that. What I'm telling you is that when you look at the compilation of evidence and research for retention as opposed to against retention, it's definitely not balanced. There's much more research and evidence to say that it has detrimental effects than there is saying that it's positive and benefits students. So I think those decisions really just have to be made on an individual basis and really thinking about all of the potential negative impacts and harm and weigh the benefit risk ratio. And is the potential for benefit outweighing the potential for harm? And that's how you have to make those decisions.
Yeah, and Dee Dee, I
So-
just want to add a little caveat here because I
Please do.
have received some phone calls, and these are more for students with low incidence and say they have been more virtual or say they have been out several times because of exposure to someone with COVID, and say they're out at 2 weeks at a time, out at 2 weeks at a time. And some parents have asked, and this is certainly a local decision too, but especially if the student is transitioning, and I'm talking more students that have difficulties with transition and more students that necessarily aren't going to, I don't want to say it this way, the impact of transitioning to another class is sometimes more traumatic when it's students that are in a resource room and are used to that. And I know I've had some parents call and say, the kid's been out a lot. They're going to be going from primary to maybe the next building, intermediate or whatever it is. And I want to hold my student back because they've missed so much. And I think, especially if it's a student of a younger age, they started school a little earlier. I think they missed a lot on social skills. So that's just something to think about too. That I'm not meaning that you are initiating that. Don't be surprised if you hear from some parents that, because I know even when I taught, there are a lot of times when parents get used to, having their students, especially if they're in a resource room that they're in for a couple years together. Sometimes that doesn't happen as much at the elementary. That big transition to the next building or whatever sometimes becomes a very scary thing. And so with COVID and being out so much, like I said, you may be receiving some calls from parents saying, can't they stay at this building one more year?
Thanks, Helen. That is such a good point. And I think what we would leave you with is what we talked about, that weighing the risk benefit ratio, because Helen's right. There are some times when parents feel very apprehensive about their child, particularly those with more complex needs in moving to a new classroom with new staff or a new building, as Helen mentioned. And again, you really have to weigh what's the possible harm and negative impacts versus the benefits of that. One thing that we didn't really talk about, but that the studies have also focused on is think about the emotional toll. And this really would be telling of why sixth graders referred to this as the most traumatic life event. Think about the emotional toll of a child being retained and all of their peers and classmates and friends of the same age have now moved on without them. And they are left to make new friends, start all over with a whole new peer group that is younger, than the student is chronologically. There is something to be said for that, thinking about for us as adults, if we were suddenly plucked from our support group, our support system, and placed in a new situation, any of us who have started a new job where you didn't know a soul, we've gone through that ourselves, and it is a traumatic event. It is very difficult to navigate. So again, a myriad of reasons why, that can be very detrimental. But as Helen said, there are sometimes legitimate reasons why you as the special educators and families may want the child to stay behind, particularly thinking about those students with more complex needs. And if they were not able to get ready for that transition because of being out due to the pandemic, certainly would be one of those situations. So again, we just go back to, it is a local decision that you as a team would make, and you really have to do the pros and cons and make that best decision that you can. So having said that, that is it as far as questions. We have a few minutes left. So if there's anything else that anyone wants to bring up, we will kind of press pause now, and we'll be quiet for a minute, let you gather your thoughts, and anything else that you want to share or ask for clarification around. Now is your chance.
Dee Dee, do you want to turn off recording if that makes it easier for people sometimes?
I absolutely will. So with this, we will sign off and give you open mic